My name is Ryan Chandrapali. I'm from Armchair Criminal. I welcome you all to this part of the program. This is the fourth part of a four-part series on common law exceptions to the hearsay rule under section 118. In this part of the program, we will consider two topics. One is rule number 7, hearsay evidence for the purposes of establishing a common enterprise. Rule number 8 is to deal with expert witnesses. At this juncture, let's take a look at what does the legislation say on rule number 7, common enterprise principle. The legislation is any rule of law under which in criminal proceedings a statement made by a party to a common enterprise is admissible against another party to the enterprise as evidence of any matter stated. I have highlighted the important parts of this provision in red brackets for your ease of reference. Then I ask myself the question, what should be established for a statement to be admissible under section 118, rule 7 of a defendant 1, that is defendant A's comments against another defendant or defendants, say B and C. You would look to, the general rule is that admission or incriminating statement of one person is admissible against that person who made the statement, but not against other people whom he mentions in it. However, there appears to be exceptions to that if the following conditions exist, and the Crown would be able to adduce that incriminating evidence of one person against another or others. And they appears to be as follows. First of all, a statement must be there that is as defined in section 115. Then there must be a common enterprise. In order to establish the common enterprise, there must be independent evidence of the common enterprise when the statement was made. That is quite crucial. We'll look at that. The statement must have been made by a person to the common enterprise. Again, that is important. Then that statement ought to have been made in furtherance of the common enterprise. And the party against whom the statement is to be adduced must have been a party to the common enterprise at the time of the making of the statement. Next, let's consider what is the rationale for allowing statements made by one party to a common enterprise to be admitted against another party to the same common enterprise. The rationale is simple and it's important in that once it is understood how this part of the legislation operates, it becomes clear that those reasons are quite logical. One, it is thought that when conspiracy is going on, no one is trying to shift blame to another. Therefore, what is discussed at this stage is likely to be true, because there is no blame game. Everybody is trying to achieve the same object. Therefore, whatever A says must be true, although it binds B, C, and D. And equally, it is assumed that A, who is making the statement, would have implied authority of others to speak on their behalf. It is equally thought that each co-conspirator knows what is going on in the conspiracy and that they all are contributing. To this extent, we have authorities of Owen, then there's another authority called Jones, William, and Barham. I have those authorities, and Owen this is a conversation that took place between co-conspirators, and it was admissible against a further accused, particularly in view of the substantial independent evidence which ensured that a fair hearing had taken place. When O was convicted, he appealed against his conviction for conspiracy to supply controlled drugs. He contended that the records of the telephone conversations of his co-conspirators who had pleaded guilty should not have been admitted in evidence because they have already pleaded to the matter and that they did not give evidence. In dismissing the appeal, the Court of Appeal could not find that Article 6 had been intended to cover such a situation. At any event, the Court of Appeal felt that even if it had been, there would have been an exception under the res gestae rule, because it is a continuous conversation whilst the offence being committed. Therefore, the court felt that the admitting the evidence did not infringe any of the rights of the defendant, and there was no unfairness. At any event, the court felt that there was overwhelming evidence. The case of Jones, Williams, and Barham, this is again an authority that I have here. This involved a conspiracy to defraud and to import Class B drugs. And when the defendant was convicted, he appealed on the basis that the judge had been wrong to admit hearsay evidence when there was no prima facie case, and two, where the evidence had been admissible, the judge ought to have given an appropriate direction as to the dangers of hearsay uncontested in cross-examination. Again, the Court of Appeal dismissed, saying that the ruling had been a model of clarity and there had been no unfairness. In saying that, first, the judge had been entitled to conclude that the two defendants, J and W, could receive a fair trial and dealt appropriately with any risk arising from the joint of the indictment, because one of their arguments was that there should have been severance. Both J and W were much more likely to have been convicted because of the weight of other evidence, and jury would not have misunderstood. There had been material amounting to reasonable evidence or a prima facie case for them to have answered the case. And in particular, the court said the conversation between two criminals was evidence against the third if all three were involved, and the words furthered the criminal joint enterprise or conspiracy, and they referred to a case by the name of Blake and Tripodi, that is an Australian authority. So you would notice that it is perfectly legitimate to adduce evidence provided that there is evidence of a joint enterprise. We looked at the rationale for that, and next we will consider what are the characteristics that needs to be established in order to admit the evidence. First is the statement. To that we visit again section 115, and this is a matter that we dealt quite comprehensively at the beginning of this part of the program, especially when we considered the introduction to hearsay evidence. Next is that a statement made in common enterprise is admissible to what extent or what type of offences. Evidence is admissible not only in cases of conspiracy, but even in cases where there are substantive offences, and it is quite common to admit such evidence in that fashion. Here there is an authority by the name of Jones, 1997 case, and here there were 6 defendants who were convicted of conspiracy to import Class B drugs. J and W, this is the authority which we just considered earlier, and another co-accused were indicted for importation of Class B. 2 others for conspiracy and co-accused had pleaded guilty. The appeals were brought on the basis that there should have been separate trials, although the charges were properly joined. This is because the appellant contended that the telephone conversations that was admissible on count 2 was not admissible against count 1, that the judge had been wrong to admit the hearsay evidence, and there was no prima facie case. If the evidence was admissible, the judge ought to have given a proper direction. As I said earlier, relying on the authorities of Blake and Tripodi, the court dismissed the appeal and said that all 3 were involved, and the words furthered the criminal joint enterprise or the conspiracy. So it is clear that this is not something that is limited to conspiracy, but can extend to substantive offences too. Does it matter one of the parties to the common enterprise is missing at trial? The short answer is no. So long as the parties were part and parcel of the common enterprise, that would suffice. I have also cited an authority of Gray and Catherine and Julia Williams. Julia Williams is a case that involved an allegation of perverting the course of justice by a representative who attended the police station to defend a suspect. And the appellate court was invited to consider whether the evidence was admissible as an exception to the rule against hearsay, and if so, whether the jury were properly directed as to the approach to assess the evidence. In this case, the Court of Appeal considered various authorities in quite detail and referred to the parts of the evidence in the case itself. The prosecution submitted that the evidence should be admitted for 3 reasons. First, the prosecution case was that although the charge was a single substantive count against the appellant, the offence was committed in furtherance of a common design between herself, Andrew, Joanne, and perhaps a man by the name of David Latin, to pervert the course of justice. Thus, each was authorized by the others in advance of that. Then, the second point was that the conversation took place contemporaneously with the interview during the intervention took place, and minutes after the disputed conversation, the appellant and they. So there had been a continuous discussion, and the police representative was quite active in a telephone conversation with a person who was not at the police station in order to seek evidence in a particular manner about a car valeting system to exclude her clients being involved in this allegation and the way that she interrupted or interposed during the interview. The judge gave a ruling, quite a detailed one, and the court, when the matter was appealed, said this in paragraph 49: the acts and declaration of one's conspirator are admissible against another if they take place in the performance of common design. If a defendant, in order to commit the offence, acts in concert with another jointly charged with the defendant or not, the acts and declarations of the other in pursuant of the common design are admissible against the defendant. If the defendant acts as agent to commit the offence, the acts of and declaration of the agent in pursuant of the defendant's design are admissible against him. However, the acts and declarations of A are not admissible against B unless there is independent evidence admissible against B of B's complicity in the common design. Acts performed and the declarations made by A otherwise than in pursuant of common design are not admissible against B. That makes it quite clear that if there was any conversation taking place in order to further a crime, and that the parties were part and parcel of that joint enterprise, they all are caught in it. However, if one of the parties was not at the material time, then that is not admissible. equally, there got to be independent evidence of people being involved in it. The Court of Appeal referred to an Australian authority called Tripodi, and that is where the issues of single count were discussed. I will just quote the relevant passage where the Court of Appeal referred. It is customary at criminal trials simply treat the presence or absence of the prisoner as a device of the admissibility of things, and it is a pity to rob that empirical but practical convenient test of any of its usefulness. But often enough, in ordinary cases, where there is no confederation or preconcert directions, instructions, and the like, although spoken in the absence of the prisoner may, according to the circumstances of the case, be admissible as res gestae or relevant facts. It is easy to understand, therefore, that preconcert, confederacy, or combination may make such directions and the like admissible when they are given by one of several acting in preconcert with the prisoner, are given in furtherance of the common design. In the present case, the thing said and done when the prisoner was not present or within earshot are for the most part of this character and are admissible as part of what was done in furtherance of common criminal purpose. There you would notice to what extent that this principle can be extended. It is a mistake to believe that if a co-defendant has pleaded guilty, or if it is a substantive matter, that hearsay evidence of this nature cannot be adduced. It can be adduced under Section 118, Rule 7, or as res gestae under Rule 4. There's the possibility of that. The next question that I would pose is, does it matter where one of the parties to the common enterprise is missing at trial? The short answer is no. If that had been the case, especially large trials where some defendants go missing, things will never get heard. That is why right at the start of the trial of the case at PTPH state, even the directions are given to say your absence could prejudice you because the case might be heard in your absence. This was a case that SFO, Serious Fraud Office, brought a prosecution against a company director, let's call A, and the manager of an Indian subsidiary, let's call man number 2. It was direct in the minds of the first and the third man. Another director had been involved in making corrupt payments to secure contracts from India and Poland. Second person had negotiated and arranged consultancy cover-up to deal with the real situation. You have man A, man B, and man C. So, man C, let's say, is acting as the conduit between A and B and pretending that this is a consultancy fee, when in fact it was no short of corruption. And it was the case that K was not party to the trial, as he was not extradited, and he has refused to give evidence. And his diary, notebook entries, and the emails were adduced. And the Court of Appeal allowed the appeal and considered the concept of directive minds of a company with the rules applicable to the admissibility of acts, statements made by one conspirator against another in the absence of the second person. The Court of Appeal went on to say that the guilty mind of the directive mind of the company came well within the rules. If the matters had been merely recorded by a conspirator for his convenience after the conclusion of the conspiracy, were not declaration in furtherance of common design and could be used to prove guilt of anyone but make of the record. At paragraph 36, the court said a corruption can only operate though is direct in the minds of the directors. Knowledge is and must remain the knowledge of the corruption. The presence of otherwise of directive mind at trial is irrelevant. Were it otherwise, as the judge observed, had directing mind might become incapacitated, as well as one whose attendance at trial could not be secured. Perhaps he had deliberately absented himself. It would not be possible to prosecute the relevant corruption, however rigorous the conduct. So you would say that even if a person is absent, it will not prevent the trial proceeding. We considered earlier that the incriminating evidence is not only admissible and limited to conspiracy, but can be admitted even on substantive offences. Next, we could consider what type of evidence is required to establish common enterprise. You would recall that when we considered earlier, it is the independent evidence that is looked at in order to make sure that the evidence is capable of supporting against the co-conspirator. Here, the case of Jenkins would be of use. The defendant stood trial on a matter. I have the authority here. The defendant stood trial with regard to receiving checks from the local authority concerning business rates. And at trial, the defendant objected to the production of certain documents on the basis that it was hearsay, because those who have signed the documents were not called to give evidence. The judge ruled that it was not hearsay even if it was. Under the old legislation of documentary evidence, section 24 and 25, the documents could be admitted. He was convicted and he appealed, and the Court of Appeal allowed his appeal, and the conviction was quashed. The reason for that, the court of Appeal felt the prosecution had failed to call the witnesses to give evidence, who created the document. Therefore, the judge was not in a position to ask the jury to infer that the signatories had colluded with the defendant. Next question that I would pose is, who decide on the issue whether there is independent evidence to establish if there was a common enterprise? This has to be a legal issue. It must be the judge. For two reasons, I would say. If the matters were left to the jury, then they might hear evidence that they ought not to hear. Then how are they then going to separate it from what could have been avoided? And in that regard, there's an authority by the name of Smart and Beard 2002. Next is, how does the statement in a common enterprise case operate? The answer is by a person to the common enterprise. And in that respect, the statement must have been made by a person to the common enterprise, i.e. involved in the crime. Section 118, subsection 6 states, statement made by a person to a common enterprise. And you would note that there's an authority by the name of Gray. Also, there's an authority by the name of Jones. If I recall correctly, I think we looked at the case of Jones earlier, and this case involved a case involving insider dealing, and the Court of Appeal allowed the appeal and rejected the grounds with regard to their submission that evidence which should have been admissible if the conspiracy was charged was inadmissible where the common enterprise was charged, i.e. if there is no common enterprise, then the statement cannot be adduced. Here, one must remember that the evidence of joint enterprise could be admissible against another person only where it can be shown the other person was complicit. That's the important point here. The court went on to say, where a common enterprise is alleged, the conspiracy was not charged. The statement made by a group member in furtherance of the common enterprise was admissible as against others applied to the commission of substantive offences by two or more acting in concert, and was limited to evidence which tend to prove the involvement of each defendant in the commission of these offences. Next, there is the authority of Jones. Again, it illustrates the point referring to the case of Tripodi, that conversations between two conspirators is admissible against the third conspirator, provided that a common enterprise had taken place at the material time. The statement made by one person that is in the case of Tripodi. Next, what we will consider is what happens if there was no common enterprise at the time of making the statement. It is obligatory that the statement to be capable of being adduced, there must have been a common enterprise in existence at the material time. Let's assume A, B, and C. A and B are already in the conspiracy, and B is telling A, I will get C to be involved in, or how we are going to do this with another person, but that the other person, let's say C, is completely innocent, in which case C cannot be held responsible for what took place, the discussion that is taking place between A and B, because that C was never involved in the conspiracy with A and B. He is the innocent party. Therefore, you would note, if the conspiracy did not exist at the material time, either because it has not started as C has not joined in at that point, or if the statement was made after the conspiracy had come to an end, then again the evidence cannot be adduced. This is the reason why I explained earlier that in cases of joint enterprise conspiracies, it is presumed that each party knows what is happening in the criminal enterprise, and each party is acting on behalf of the other, like agents. That's what they are. And there is no reason or rhyme to feel that anybody would be trying to stab in another's back, because everything is working smoothly at the time. Their common object is the same. What they want to achieve and the way they want to achieve is the same. Things fall apart at the end of the conspiracy when things go pear-shaped. That is when they want to say, he did this, he did that, nothing to do with me. That is when the lies, deceptions can come in. Then the next thing that we will consider is the authority of pattern. Here, a conversation took place in a car belonging to co-defendants who pleaded guilty to the conspiracy. This is again a case of a conspiracy to supply drugs. The main issue in the appeal was whether the recordings had been admissible to prove P's participation in the conspiracy. When he was convicted, he appealed. In dismissing the appeal, the Court of Appeal said, 1. The question of admissibility was for the judge alone, not for the jury. No criticism could be made of the judge's summing up. The exclusion of mere narrative applied only to narrative after the conclusion of the conspiracy. Statements made during and as part of conspiracy, because they were part of the natural process of making the arrangements to carry out the conspiracy, were admissible. This is exactly what we discussed. Right up to the point of the conspiracy ceasing to exist, everything becomes admissible. Now we have looked at these authorities, namely examples where it was argued that the statement was not admissible. And it is clear that if the statement was made before the relevant person became involved or after the common enterprise has ceased to exist, then those parts of the evidence could be excluded. Next, let's ask ourselves, what is the procedure to adduce evidence under Section 118, Rule 6, as a statement made as part of the common enterprise? 1. There has to be an application. The judge decide whether a common enterprise exists based on conditional basis, namely evidence could be adduced but given the rider. and if the conditions are not met, careful directions may need to be given, or where that cannot be met, then the jury ought to be discharged. Where the case is left for the jury, careful directions must be given in order to deal with the issue. That is all I intend to talk about common enterprise. In essence, it's quite easy. If the statement was made before the conspiracy or the joint enterprise took place, or after the joint enterprise or the conspiracy had ceased to exist, evidence cannot be adduced. Equally, at the material time, the party who is affected must be part to the joint enterprise or the conspiracy. If they are not, then that is not admissible. It is always the judge who decides on whether there is independent evidence, whether there's a conspiracy existed at the material time. They are legal issues. Where else the weight and the like, that could be left to the jury. Next topic that we will deal with is Rule 8 of Section 118, expert evidence. So let's ask ourselves, what's the first thing? What does the legislation say? Rule 8 say, any rule of law under which criminal proceedings an expert witness may draw on the body of expertise relevant to his field. It is quite clear that the person must be an expert and that person can refer and give opinion based on his experience and knowledge of that expertise field. Rule number 19 in criminal procedure rule governs the admissibility of expert evidence. The important parts to bear in mind: the expert witness not need only have the relevant qualification, the witness must be independent, must have the requisite qualification, and the expert's duty is to the court, not to the party that who instructed or gave an undertaking to pay the fees. And the material that is to be referred to in his or her report must be outside the experience and the knowledge of ordinary individuals. In other words, without the expert evidence, one cannot understand, be it the quality of drugs, how the gang violence takes place, or how firearms and ammunitions, DNA, those things are not generally within the understanding of ordinary people. But whilst the expert is able to give evidence on those things, the expert cannot usurp the function of the tribunal of fact. They cannot give evidence as to what the final result should be. The ultimate answer should be left to the jury to decide. Now, I hope I have explained and covered these two rules comprehensively. Remember, not only these two rules, but as a general rule, save for the common law exceptions that are expressly reserved in this Act, there are no other exceptions under the heading. under the heading of common law exception. No, there is room to develop any further. Where there are any gaps in section 118, the courts will always rely on other parts of the legislation to fill any gaps. I hope you have found this part of the program helpful and enjoyed it. Next we will be considering res gestae and confessions. Thank you very much. God bless.